Hello everyone, my name is Benita Zude and I am a graduate student in the Healthcare Administration program at Texas Tech University Health Science Center, currently enrolled in the Health Law and Ethics course, and today I will be presenting a case brief on behalf of Group 5. The case I will be addressing today is the Stowers and Wolodzko case that was decided in 1971. So before we get into the presentation, I just want to quickly outline what we'll be talking about today. First, we'll go into the overall introduction. Then we'll talk about the initial legal actions that actually occurred in trial court that kind of leads us to this case. And then we'll go over the facts and issues presented. And finally, we will end with the holding and some extra analysis that my group and I kind of discussed about how the matters in this court case actually affects our modern healthcare industry today. The Stowers and Wolodzko case was an opportunity for us to really critically reevaluate some of the federal and state government regulations that are put in place specifically to protect patients from wrongful actions conducted by healthcare institutions and professionals. It is really, really important that it's emphasized that healthcare professionals must allow individuals to exercise their freedom to accept and receive qualified treatment, even if their decision kind of goes against what is recommended by a physician or a psychiatrist. The patient's autonomy must always be honored, right? Unless they are not in a position, health-wise or mentally competent enough to make that qualified decision. But other than that, it is within their right as an individual, as a citizen, that they can be able to make their own choice. So before we really get into this case, we have to think about the time period that we are in. In the 1960s, psychiatric care and medicine for mental illness was still a developing practice, and society at that time did not entirely agree with some of the evolving information from mental health research. Back then and also today, psychiatrists can confine a patient, if they do have a court order, to a mental health institution if the person proves to be a danger to themselves or to another person. That's why it's really, really of concern that we make sure that there are clear regulations to protect patients, right? We don't want anyone with that type of power to kind of abuse it, and for a patient to be in a situation where they might get misevaluated or confined against their will. So Ethel Stowers filed a complaint against Anthony Smike, Joseph Wolodzko, and Ardmore Acres Hospital. There was a trial order to remit her, which basically gives the trial court the ability to make corrections to excessive damage award or a verdict without having to order a whole new trial. And this is all within the plaintiff's consent. The lawsuit was restructured to focus really only on Stowers' disputes with Wolodzko. Anthony Smike and Ardmore Acre Hospital was given summary judgments. Now, the main reason why Ms. Stowers took legal actions is that she claimed that Dr. Wolodzko falsely imprisoned her against her will, inflicted assault and battery, and was liable for malpractice because he administered treatment to her without her consent. A trial court took place in Livonia, Michigan. Wolodzko did make a request to receive a direct verdict regarding all the alleged charges, but he was only granted a direct verdict for the malpractice accusation. All the other charges had to be determined by a jury. Okay, so now going into the facts of this case, let's address the main people who are involved. Ms. Stowers, she is a Michigan housewife, a mother of 2 young children, and she is having some issues in her marriage, and it's gotten so bad where she's actually intending to get divorced. Mrs. Stowers' husband is actually the one who reaches out to the defendant, Dr. Wolodzko, to perform a psych evaluation on her without her knowing. So it's very interesting diving into the facts of this case because it really is a he said, she said type of moment. Mrs. Stowers is very, very stern on the events that have occurred throughout the dates that I'm about to mention. But it's very interesting to see how on court records, Dr. Wolodzko really kind of not being able to recollect exactly what occurred on his account. So which kind of makes this case very tricky when it comes to evidence. So going in, it really all starts December 6, 1963, and the defendant, Dr. Wolodzko, shows up to Mrs. Stowers' home, and he's stating that he is just here to check on her husband's back. But he never introduces himself, at least from Mrs. Stowers' point of view, as a psychiatrist. Right? December 30th, 1963, at the request of the plaintiff's husband, the defendants, Dr. Wolodzko and Smike, signed a sworn statement saying that the plaintiff had been examined and found that she was actually mentally ill. On January 3rd, 1964, a certificate was filed with Wayne County Probate Court where the plaintiff was ordered to be committed to Ardmore Acres Hospital until a sanity hearing could be held. On January 4th, 1964, two men in white coats arrived to Mrs. Stowers' home along with the defendant, Dr. Wolodzko, to take her to Ardmore Acres. The two men pushed past the plaintiff and they grabbed her while Wolodzko stated she was to be taken to an institution as she was mentally ill. Wolodzko showed her Mrs. Stowers the court order, but he will not allow her to read it. Mrs. Stowers requested to use the phone, but no one answered her. When she went to go get dressed, she rushed to the phone to see if she can call the operator, but she had the phone taken away from her, and she was pushed into the room to go and change. From Wolodzko's point of view, he does not recall seeing her go to the phone or for that situation to even occur. So we can already see where the discrepancies start to lie. On January 4th, 1964, all the way through January 27th of that same year, this all happens in, the following all happens in Ardmore Acres Hospital. So Stowers was held in security room for 6 days and did not eat for the first 5. Wolodzko requested permission to treat on her on several occasions, but Mrs. Stowers refused. At one point, Mrs. Stowers was held down by 3 nurses and forcibly injected with medication ordered by Mr. Wolodzko. Mrs. Stowers was not given permission to use the phone or write and receive letters at Ardmore Acres Hospital. She was allowed 1 phone call to her children after 9 days of confinement, but she was never allowed to call an attorney. In this, I believe when she was trying to make a call to her attorney, that is when there were threats made by Dr. Wolodzko, stating that she'll never see her children or family again, which is very interesting. And we can kind of see from an outside perspective how stressful of a situation this could have been for Mrs. Stowers. Stowers finds an unlocked phone and she was able to reach family in Texas. Soon after, Stowers was released by court order on January 27, 1964. So moving into the issues of this court case, it is very interesting that these are some of the problems that Dr. Wolodzko actually has. And let's just go through some of the concerns that he raises. The first issue is, could the jury even find the defendant liable for assault and battery? And the second issue addresses whether or not there was evidence enough for a jury for them to conclude that they can accuse him of false imprisonment. So we need to make sure we kind of also address that he does have a court order because of his evaluation of Mrs. Stowers that she was mentally ill. The due process of everything, if you have a court order, gives him legal access and authority to confine her. I think where he starts to overstep some of the boundaries is that one, Ardmore Acres Hospital is not a state institution. It's actually a private hospital. So some of the, I guess, covering that he would have gotten is kind of removed, and the law is more open to interpretation because the facility that Mr. Stowers was actually held in is a private institution. Also, they both agree on this fact that he did give her treatment and administer treatment, even though Stowers refused and did not give consent. That right there is a huge issue, and that it kind of debunks a lot of the appeals that he was trying to make. The third issue: did the defendant actually commit a tort of assault and battery? Again, what really messed him up here is him admitting that he did, in fact, administer treatment. You cannot give treatment to a patient if they have not given consent. So him just overstepping that boundary and kind of abusing that power is really what's gotten him in a very place where a lot of this things that he's trying to say isn't justifiable. He's not having enough evidence to contradict what Mrs. Stowers is saying. The fourth issue: the defendant contends that a different issue was submitted to court than what was actually ruled upon. And in the Court of Appeals, they actually debunked that. They're saying that whatever was confirmed in the trial court that he understood, and all parties understood what was being, what matters and charges was being presented. So that could not stand. And for the fifth issue, the defendant claims that the damages awarded were too excessive, that Mrs. Stowers was awarded $40,000 for her pain and suffering, that was just too much money demanded. And the way that the court kind of addressed this is that with pain and suffering, it's really hard to even put a number on someone's pain and suffering. How do you even quantify that? And that's something that we are still trying to figure out in our court systems, especially regarding health law and tort reforms regarding the healthcare system. We're really trying to figure out, how do you quantify something like that? And how can we make sure that people aren't taking advantage of the system? But in this particular case, Ms. Stowers was the court definitely deemed that it was justified. There was, I believe, a moment where the excessive damage award was reduced from $40,000 to $30,000, but just like Dr. Wolodzko, Mrs. Stowers counter appealed, and it was found that the $40,000 was actually justifiable, and it was reinstated. Okay, and now coming towards the end of the presentation, let's get into the judgment and the holding for this case. So for the judgment, the defendants, Smike and Ardmore Acres Hospital, they were dismissed before the trial, and they were issued summary judgments. The court did award the plaintiff, Mrs. Stowers, an amount of $40,000 for her pain and suffering. At the defendant's request, they did try to grant a new trial that reduced the $40,000, the initial $40,000 award, to $30,000. And then in the court appeals, they actually reinstated it by the jury verdict of the $40,000 for Mrs. Stowers. And for the holding for this case was solely based on the 4 precise charges made by Mrs. Stowers. The court made the decision to dismiss Wolodzko on the grounds in which no evidence proved malpractice. The defendant argued that it was his obligation to medically treat the plaintiff. Thereafter, the defendant was charged with battery and assault and false imprisonment by the jury. The court's decision to dismiss malpractice was determined due to a lack of evidence prior to the plaintiff's hospitalization. Wolodzko was charged with battery and assault due to the lack of permission to medically treat the plaintiff unless she was in a position to harm herself and others. And again, even though he did make that evaluation that she was mentally ill, to know that she was released, after a week or over a week, kind of discredits the fact that maybe she was in a state of insanity. So let's go into a little deeper analysis and let's pose some questions that we can think about for the present day. So how should healthcare administrators prepare to deal with these type of implications that were arised in this court case? The biggest thing that I have seen us kind of practice in the healthcare system is documentation. Nurses, physicians, healthcare personnel, they are not required to do very extensive documentation, going into detail, talking about what was actually evaluated with the patient, the treatment provided, the medication taken. It's so important to be very thorough, because lawsuits can happen all the time, because mistakes can happen all the time. The only way to really back up some of the decisions that you're making is through documentation. Also, signed agreements and contracts, giving consent that a patient, written on paper, consented to a treatment. That's also very important. And even if a patient chooses not to receive treatment, and you know that will put them in a state of crisis, or you know that might, really be a disadvantage to their health, that also needs a signed agreement so that you are not liable. So those are things that we've just been more stricter with regulations, and the accountability on healthcare physicians and personnel. There's just so much more of an added weight, because malpractice happens all the time, and it's a very expensive situation when you are constantly sued and you're not making sure that you are dotting your I's and crossing your T's. And another question that we kind of think about here is, what will be different today if the case took place in our current time period? We should think about, currently the great push towards tort reforms in the healthcare industry. Healthcare institutions and private businesses are tired of losing so much money. The whole process, the legal fees, and the amount awarded for damages for pain and suffering. It's a lot. It's been very excessive. And again, there is that debate of can we really put a number on someone's pain and suffering, especially if malpractice did in fact occur. But now with the recent changes in tort reform, I wonder if Mrs. Stowers in this present day, if it would have been so easy for her to be awarded the $40,000. I think because of the severity of the case, that she was in a confined place, and false imprisonment is a very serious crime. Regulations are even way more stricter now than they were back then. As healthcare professionals and people who want to make an impact on health law, are we putting just as much emphasis to ensure that we reduce the number of malpractice cases, and kind of finding that balance, and not only just focusing on putting a limit to the amount of monetary award you can get for damages and pain and suffering. So that's all something to really think about. Thank you so much for your time and your interest in our presentation. Here are our resources. If you have any questions, you can always contact us. And again, thank you so much for your time.